Section 6 is the right to travel anywhere in Canada or leave Canada.
That's being infringed upon right now.
No conditions. No. Not just in one province, not just in some province, not just when it's convenient, right? This is open-ended. This is a right in the Constitution, not in the Federal Act, not in the Provincial Act, but in the Constitution of our nation.
Hello, everyone, and welcome to another episode with Students Against Mandates. We are thrilled to be joined today by the Honourable Brian Peckford, former Premier of Newfoundland and the last living signatory of the Canadian Charter of Rights and Freedoms. So, Mr. Peckford, just to begin, would you be able to give our audience a more in-depth introduction of yourself and tell us what has compelled you to revisit the political scene?
Okay, yeah, sure. No problem. I went through university like you people are doing and graduated from Memorial University back in the Middle Ages, 1966. It might seem like a long time ago. And then I went teaching. And my majors were in English literature and history, mainly economic history. And then I taught for 4 or 5 years, but I quickly got the political bug. I had been on student council at the university. And so I got involved in, if you will, some type of politics early on as a student. But then went out teaching high school in rural Newfoundland and witnessed what was going on. And I just didn't like it. So I started to write letters to the paper and started to comment upon these things, which got me involved in politics. And so to make a long story short, I got elected to the riding that I was teaching in. I wasn't born there. And I was the first Conservative candidate ever elected to that riding. It was the only one left in the province that had never been Conservative in its history. And I'm talking about a history that went back to 1832 to 1972. And so I sort of broke that and became the first Conservative MLA for that riding. And then within a few months, I was working in the Premier's office and was the parliamentary assistant to the then Premier. And then I moved to become a Minister of Municipal Affairs and Housing, then Minister of Mines and Energy, Minister of Rural and Northern Development, and so on. And then ran for the leadership in 1979. So I got elected in 1972 to the legislature of Newfoundland. And in 1979, I ran for the leadership against 8 or 9 other candidates. I wasn't supposed to win my riding and I wasn't supposed to win my leadership. So my history is one of never supposing to win, but always managing to win and sort of upset the apple cart. So I wasn't what you would call the favorite boy of the party at any time or with any one group. I guess my whole history is one of being more independent and speaking out, even when the party didn't want me to speak out or whatever. Then I became leader and automatically Premier of the province. That was in 1979. And it was only a couple of years that I was Premier when the whole patriation and began, the whole constitution making began. Of course, as you might know, if you've studied any of this, this goes back some years before that, with First Ministers trying to negotiate a patriation, in other words, to have the Constitution completely a Canadian Constitution and to sever all of our ties from a constitutional point of view from England, from the home country. But it could never get finalized because the provinces and the federal government could never agree on an amending formula going forward. That was one of the big stumbling blocks. And that's in the Constitution Act that we now have, in which the charter is located. So I want your viewers to know that we're talking about a major constitutional change, not just the Charter of Rights and Freedoms, but we'll concentrate on that as I go through this, okay? But I want your audience in particular students and students interested in this to understand what, and hopefully some of you have done some history and understand that it's always a bargain. If you go back to Greek times and you go back to Solon's time when he reformed the government of Athens, well, he saved Athens, as a matter of fact, a retired merchant he was at the time, but it's always a bargain. And he had a bargain between the poorer people and the people who were not even citizens with the oligarchs of the time, with the wealthy people of the time. And he made a bargain which saved Athens and gave some more rights and freedoms to people who didn't have them before. And I just say that as a historical backdrop so you understand this has been the course of history. Everything in humankind is not an easy thing to do when you're trying to get people together to form a state or to form whatever. And so I think for your audience, it would be important for me to point out right at the outset that this was a bargain and it involved many things. One of the most important ones was actual patriation. So we became a sovereign nation and could amend the Constitution in our country in the future without having to refer back to the old country. But it also included the Charter of Rights and Freedoms, which is now front and center in our country. But it also included an amending formula. How are we going to amend our Constitution in the future? It included minority language rights. It included non-renewable resources between the provinces and the federal government. It included a number of other things, including Indigenous rights. Never before, since 1867, when our country was formed, was there any identification of the Indigenous people of our country and who they were. And in Section 35 of the Constitution Act, in which the Charter is located, is a very important section dealing with Aboriginal rights, in which we actually identified who were Aboriginal. That was the Innu and the Inuit and the Métis. And that wasn't done before. They both automatically had, if you will, for want of a better word, status, or had recognition as individual native groups of our nation, right? So I'm only explaining this to demonstrate to you the bargain, okay? So all of these things were in there. The Charter is part one of the Constitution Act, and there are 6 other parts, the ones that I just listed, or most of the ones that I just listed. So it was a bargain. Now, on the individual rights and freedoms side, which is now taking dominance because of what the governments have done over the last 2 years, there never was in our original Constitution, the V&A Act, any written rights and freedoms for individuals. It was 0 written. We depended upon British common law and customs and conventions that grew up after 1867. And customs and conventions meaning, in constitutional terms, things that happen that consistently happen. You can't have a custom of convention if it only happened once or twice. It has to happen many times and be almost identical, if you will, in order to really call it a convention in constitutional terms. So it was thought, especially as a result of America, the elephant to the south, that they, with only 15 years after they had a country, amended the Constitution to include the Bill of Rights, as we've all heard of many, many times. As Canadians, being the mouse next to the elephant, you hear a lot about the elephant. And so it was natural for Canadians over the years to wonder, at least, why we didn't have a written Bill of Rights or a written constitutional provision which protected, in writing, the rights and freedoms of its citizens. This is not universal, and there are a lot of people around today who are questioning me in advancing or talking about the Charter of Rights and Freedoms like I do, and say it was better if we just had British common law and the Brits got along fine with it, and so on. And there is an argument to be made on that side, and you can still go to court today under British common law. because the Constitution of Canada now consists of the British North America Act, 1867, which brought the country into existence. And it consists of all the conventions and customs that came with that right through to now, plus the new Constitution Act of 1982, which included the Charter of Rights and Freedoms in writing. So whether, in fact, these other arguments that some lawyers are making today are valid or not, the long and short of it is we do have a written Charter of Rights and Freedoms, and people look to it to defend their individual rights and freedoms, given that it's in writings and you don't have to go through the thing of finding British common law precedents, which can help you in your court battle alone. You have something in writing that you can depend upon. Or at least that is what we thought, and I thought when I helped create this document. This is what we thought. Unfortunately, I'm the only one left of the first ministers. There's some ministers left who've been quite quiet, and a lot of scholars and bureaucrats who have been quite quiet since all of this stuff has happened on the pandemic front, in which governments have initiated mandates and other things which have, in my view, violated the written Charter of Rights and Freedoms. One has to wonder why they've stayed so quiet even to this very day, and it baffles me. I guess a lot of them are at universities, which depend upon public funds. A lot of them are back in law firms. A lot of them are retired, don't want to be bothered with it, or whatever. I don't know. And no doubt there are a range of reasons, some of which are not as savory as others, for sure. In any case, in 1981, after I was Premier only a couple of years, there was another effort made to patriate the Constitution and at the same time have a Charter of Rights and Freedoms and clean up a number of other matters that you heard me just talk about, okay? And so we sat down to see if we could now get an amending formula, get a charter that everybody could agree to, and the other issue that I mentioned. And we didn't get very far. It was 17 months. A lot of people forget, almost 18 months, 17 months of talks between the provinces and the federal government trying to work out this new Constitution Act. What really happened was that the Prime Minister at the time, who was the father of the present Prime Minister of our country, left the table. Unfortunately, this is not well known in our history, primarily because the dominance of the Liberal Party and the federal government in our lives has increased to the point where things which are not as positive towards their side doesn't get the same coverage as it should. And this has only happened really in the last 40 or 50 years to the extent that it really matters. And but he left the table and said, "You're too difficult to deal with. I'm going to do this unilaterally. I have the power to do this unilaterally." Now, remember, as we all know, this is a federal state where the powers are shared between the federal government and the provinces, okay? Germany, Australia, United States are all federal states. Switzerland is perhaps the best example in the whole world because they have perhaps the most decentralized federation in the world. The cantons still have a lot of power in Switzerland, and they have their own referendum and so on. So that was when the provinces got quite angry with the Prime Minister, and 8 of us got together and challenged what he was going to do. He true to his word, he introduced a bill in the House of Commons to patriate the Constitution with his version of the Charter of Rights and Freedoms, had it passed by the House of Commons, and was moving ahead with it when we challenged it in the courts. And so the 10 provinces split. 8 opposed what he was doing, and 2 stayed with the federal government. Ontario and New Brunswick remained with the federal government and said, yes, he can do this. The other 8, including your province, Manitoba, which, by the way, you should be very proud of. You had a very, very good premier.
Sterling Lyon.
He might be the most flamboyant person in the world, but Sterling Lyon was a stalwart. And I want you, when all this is over, to take time to go back and read it with Sterling Lyon. And I do this in almost all of my podcasts, not just because I'm talking to Manitobans now. I do highlight Sterling Lion, because he was a real, what shall I say, Canadian and a very strong Manitoban. And he was always concerned about the Charter and whether it would do what it said it would do. He was the one voice who did say, I wonder, will this last, even though it's in the Constitution? Now, you have to understand the backdrop to the individual rights and freedoms was really Canada sort of came out of its cloak to really identify individual rights and freedoms as being important in 1960 with another Prairie Prime Minister, John Diefenbaker. Because John Diefenbaker's government brought in the Bill of Rights. There is a Bill of Rights in Canada called the Bill of Rights, in which he identified all of the individual rights and freedoms that are in the Charter. But it was only a federal law. And as we know, that only applied to federal jurisdiction, not to everybody in the whole country. Right? But he has to be given a lot of recognition because he actually put in writing individual rights and freedoms. Once again, not well known anymore, but very important in looking at the history and the trajectory of of this as I explained it to you. So we were building on the Bill of Rights. And the reason why we were putting it in the Constitution, and this is what I don't think some of the judges understand anymore. By the way, I last night and this morning, I've been reading one of your Manitoba judgments and the British Columbia judgment as it relates to the Charter. And I'll be posting an essay on it in the next 24 hours, quite likely, just showing how they abused the Charter. And of course, as we know, you and I know. Anyway, so we were building on the Bill of Rights of 1960, really. And so we must mention John Diefenbaker, but we were putting in the Constitution so it would apply to all Canadians. Because a Constitution is a national document, whereas anything the federal government does or the provincial government does is federal or provincial. It is not national. And that's one of the other points that which got me going on this thing back a year and a half, 2 years ago. Well, very few people recognize the difference between federal and national. They think they're synonymous. And of course, they're anything but synonymous, right? Because we have a federal state and powers are shared. And so in order to make it more permanent, because that's what the Constitution is all about, permanent values, glue that bring a country together, it was going to be put in the Constitution and therefore correct one of the flaws of the Bill of Rights, because it was only a federal act. And you know what a federal act can do, especially in today's world, it can get changed pretty fast. But a Constitution can't. Okay, more difficult to open a Constitution. So it gives it permanence, right? So that's why the Charter of Rights and Freedoms is in the Constitution, because that's where it belongs if you're going to protect for all time, if you will, the rights and freedoms of individual Canadians. In any case, we took the Prime Minister to court when he left the table in Newfoundland, Quebec, and I think Manitoba. And said, you can't do this. This is unconstitutional. That's against all of the conventions since 1867. We're a federal state and you cannot do this. This is unconstitutional. Now, remember, in those days, the press, just bowed at Trudeau's feet. He was a constitutional scholar. He was the person, he was the brightest person in Canada. So the press said at the time, highly exaggerated, highly overrated. He was a bright man. So was Hitler. We shouldn't go there about brightness anymore. That's a very dangerous thing to put forward in and of itself. It needs a lot of other stuff to describe it before you start getting into a person's character and judgment and all the rest of it. I've come to learn that over the years many times. Sometimes I learned it quick enough and sometimes I didn't learn it quick So in any case, we took him to court, and it was obvious that we had some really good cases. So it was in Newfoundland. We picked 3 rather than do all 8, right? And it was obvious, and the court started to rule against Trudeau. And so what everybody agreed to was, because now all of a sudden Trudeau thought he was maybe in trouble, and perhaps he should refer to the Supreme Court himself, which he has the right to do as a Prime Minister, as every Premier does, by the way, to refer any matter to their highest court if they want to see if it's constitutional. And we'll come back to that again in a few minutes, because I did that, and none of the Premiers replied to me if they wanted to see if they're right, if they're what they were doing on the pandemic mandates were constitutional. In any case, so the court decision came down on September 1981. I think it was September 28th, 1981, by the Supreme Court of Canada. And I usually preface that decision by saying the following, which I think you'll begin to appreciate if you don't already. There was a time not too long ago, in 1981, when even though most of those judges of the Supreme Court were friends of the Prime Minister, they were friends of the law first.
Very, very important.
Very, very important. I get emotional on this score because it's so important. And they ruled against their buddy. They ruled against their fellow constitutional scholar and said, no. This is unconstitutional. You must consult the provinces and have a fair number of provinces on side before this becomes constitutional. So what did the Prime Minister have to do if he still wanted to proceed like we had started? He had to come back to the table. And so he came back to the table, and we had 3 days in which we was going to make or break, because we had been at it for so long. November 3rd, 4th, and 5th of 1981. And on the day of the 3rd, nothing. Talks, no breakthroughs. The day of the 4th, no breakthroughs. That evening, I presented a proposal that myself and my delegation prepared to a few provinces to see if this is where the compromise could be. And they thought it was a good one. It was involved initially in that was British Columbia, Alberta, and Saskatchewan, and me. I went over to the Saskatchewan suite in the Chateau Laurier Hotel on the night of the 4th of November and said, I sent my 2 deputy ministers over to see if there was any chance before I got involved or before I started to push it. And these representatives from the other provinces were in touch with their premiers. And Premier Blakeney was present throughout all of it because it was in his suite that we went. And they said, yeah, we think this has a chance. So then we called the other provinces in. I think it ended up to be 4 or 5 premiers that night and all 8 the next morning for breakfast. And through the night, we amended what we had presented. And then I presented it to the full group of 8 of First Ministers the next morning, and it was approved. Then we presented it to all the First Ministers, the 11 of them, that afternoon. And that ended up with a few more amendments being what we got today. Now, I want to show you something. And I'll send it to you because you really need to have it. Some people recently, I was on CTV News even, trying to discredit me very, very stupidly because they talk about my name, Peckford's name is not on the Constitution Act. Therefore, he had nothing to do with this. Well, remember, this, what we signed that 5th of November, was a patriation agreement, which authorized the Constitution Act of 1982 and is the same thing, only in different format. It is in a constitution. It's in a law that was passed in the House of Commons and signed by Her Majesty the Queen, on which was signed then the Attorney General for Canada with the Prime Minister and the Queen. So no, my name wasn't on the Constitution Act. But what caused it to happen was the Patriation Act, because as the Supreme Court of Canada said, unless you got a majority of the provinces, no deal. So you need to have them on side. So the Patriation Act, and I lost this and just found it a few days ago.
That's
And I've got
it.
this is document 5. Can you read that?
Yes, November 5th, 1981.
Yep, there it is. It was only 3 pages because we had worked out a lot of it. So therefore, in here you see, number 1, what were we agreeing to? Patriation. Okay. We were agreeing to an amending formula, right? And number 3, Charter of Rights and Freedoms, right? But we made a number of amendments to it, so it got approval by everybody. That's page 1.
On that.
Page 2, we'll go through a few other things, and then the signatures. Now, I don't know how many of these documents are around. There's likely not many. On this page, it's Pierre E. Trudeau, William Davis, and John Buchanan, Premier of Nova Scotia. Now, if you know anything about Canadian constitutional history, you'll know why it's in that order. Do you know why it's in that order?
I heard.
And then on the next page, who's after Nova Scotia? Who's after Nova Scotia? New Brunswick comes next. And then who's after New Brunswick? You can read it there.
Manitoba.
Manitoba. Okay, British Columbia. Okay. And all the way down to the last one,
Newfoundland.
being me.
There you are.
Yours truly.
Why am I last? Why is Ontario first? Got nothing to do with size. It's got to do when they came into Confederation. And that's the way we sat around the table. And that's the way all official documents are signed. Okay. So we were the last to join Confederation in 1949. The 4 that joined at the beginning and formed Canada were Upper Canada, Lower Canada, Nova Scotia, and New Brunswick. They were the only 4. Upper Canada being Ontario, Lower Canada being Quebec. Okay?
So they sat on either side of the Prime Minister as well.
Exactly. Good for you. Exactly. Exactly. But there is a document. I'll send you this on your email, Brandon. So you have a copy of, and it'll be a photograph of three photographs showing those 3 pages. Just so you have it as a result of this talk today. So, and then if anybody ever argues with you,
just hold it up. Right here, his signature.
What was Pierre Elliott Trudeau like? Was there any similarities with Justin, or what would you say?
Oh, very much so, especially on the stubborn side and the arrogant side. He gets it all right enough, you know. Pierre Elliott Trudeau was a cool, calculating person. One of the things you might enjoy is that René Lévesque was just a difference. Now, as you notice, Quebec wasn't on this. The only ones who didn't sign this was Quebec. Quebec objected to it, and they still are not. We're one of the few countries in the world that don't have one of our largest units a part of the Constitution, especially the Constitution Act of 1982 to this very day. But to get back to your question, René Lévesque, notwithstanding that we disagreed with him on this, and has been very often cited as sort of the villain in many stories that have been told, was an extremely entertaining person. Highly knowledgeable about every place in the world. You couldn't ask René about the smallest little atoll in the Pacific without him having a story about it. And so it's really interesting during that period, those 17 or 18 months, really interesting because we would laugh with René about a story he told. We never ever laughed with Trudeau about a story he told because he never told any humorous stories. He wasn't that kind of a person. And so René would get on Trudeau's nerves. Well, it was really jealousy, really, because René was entertaining us. And he couldn't. even in the most serious moments when we'd stop and pause for a while or whatever, have a recess. The Pierre Elliott Trudeau was not one of those people. And so he really, resented the fact that Rennie could entertain the first ministers and get along with all of them. We all got along with Rennie, even though we violently disagreed with them on the future of our nation. Otherwise, he was the most pleasant of people that you'd ever want to meet, and unbelievably engaging. And like I say, very, very knowledgeable. I mean, he was only with this great big head, right? With a cigarette in his hand all the time. I don't have any photographs of Rennie without a cigarette.
That's amazing.
Yeah.
So going back to the charter and the development of it, did Pierre Trudeau put anything into it that would allow Justin Trudeau to implement these COVID mandates at this current time?
No, not at all. As I say, his charter was lost.
Yeah.
The Supreme Court of Canada ruled against his charter. And the charter you have is a charter that was agreed to by 9 premiers and him, right? And we had put amendments in there that wouldn't be there, right, if he had full sway. He didn't want the notwithstanding clause in, for example, the famous notwithstanding clause, because, and that was in there. Perhaps 60% of the reason it's in there is because he left the table and we couldn't trust the federal government anymore. Now, British Columbia and Alberta in particular had said to us all along, and Rennie, that, he's going to leave the table. He's going to try to do this on his own. And the rest of us naive guys said, no. He's to the table, he'll stay at the table. They were right, we were wrong, including Sterling Lyon. They didn't trust Trudeau, nor the federal government very much. And of course, that manifested itself tangibly when he left the table, so that all of us were highly suspicious after that. So when we forged the deal, one of the reasons why the notwithstanding clause was in there is because we couldn't trust what the federal government could do, and therefore we could opt out at certain times. In Newfoundland's case, for example, somebody asked me the other day, well, give me an example, of that. And I pointed out to them, and this happened, I don't know, it was before or after the charter. I think it was before, but very often when the federal government got involved in various areas of provincial jurisdiction, sometimes with the approval of the province, other times without it, they would just run roughshod. For example, you're too young, but there was a time when there was no manpower training from the federal government. It was all provincial. Okay, what manpower training there was. Well, then they created this manpower and immigration or whatever it was department. And the federal government participated in manpower training across the nation. They introduced at one point a new training program that applied to every province in Canada except Newfoundland. Didn't apply to Newfoundland because the area of training that we wanted was quality control for fish plant workers, and had a special program because, and at that point, Newfoundland was highly dependent upon the fishery, and we had scores and scores of fish plants all over the province. And we were competing against Iceland and Norway and other places where quality control was much better than ours. We needed to get ours up so we could sell our product on the international market. So we had to fight to get that put back into the program. They could have went ahead and did it. Well, there are things like that that can still go on, that where provinces then have perhaps the opportunity through the notwithstanding clause. And again, in Ontario, when the Premier Ford, in recent times, when the city of Toronto, from his point of view, and from the point of view of many people across the country, it sort of gotten out of hand with the number of seats they're going to have, and so on. It was really getting to be disproportionate to what they really needed. And under the Constitution of the BNA Act, the municipalities are completely provincial, 100% provincial. So the province has complete control over cities and towns and villages and whatever. And so Premier Ford had just been new, but he wasn't going to allow, he was making it more or less a point too. He wouldn't allow Toronto because it was decided just to dominate everything. And he wanted to send a message. But besides which, he was right on this one. It was getting out of hand. And so he was going to reduce it. He could bring in his own act to reduce this. Amend the City of Toronto Act and amend it and say there's how many you can have. councillors you can have in your city. And anyway, went to the Supreme Court of Ontario, and he threatened to bring in the notwithstanding clause, but he didn't have to because, thankfully, the Court of Appeal. But would you believe that there were judges on those courts that were saying that perhaps the province couldn't do this, even though the BNA Act said everything was municipal was provincial, like that a 4-year-old could read or a 4th grader could read? But in any case, there was a Court of Appeal, because we're going to come to that in a few minutes, Court of Appeal judge who said, get out of here, right? BNA Act section such and such. Municipal is provincial. End of story. So he can, whether you like it or not, he can do what he said he can do, and he doesn't even need the notwithstanding clause. Right?
Okay.
But that's a really good example because it just shows you how far enough. So anyway, I'll come to it in a second. So all I want to say now is, and then you can get into your questions more. I want to just take it one step further. Right from day one, there were people who didn't like that charter, nor did they like yours truly. And so all of the early books that were written on the Constitution, and you'll still find it if you Google in now or go in whatever new platform you want to go in on. Google is not so good anymore, nor are any of them. But if you go in and you read, even in the Canadian Encyclopedia, they may not even give me any notice at all about what happened on the night of the 4th and the morning of the 5th, and what proposal it was that broke the impasse. Apparently, it was Mike Duffy, the senator, who was then in the press, who, what shall I say, talked to Roy Romano, who was then the Attorney General for Saskatchewan, Roy McMurtry, who was then Attorney General for Ontario, and Chrétien, who was then Attorney General for Canada. And they gave him a story that he ran with immediately without even verifying it. That they were the ones who, on a little slip of paper in the kitchen of the Chateau Laurier Hotel that night, nobody can find this piece of paper, by the way. And this paper is fictitious, but we can't find it. But they were the ones who brokered the deal. Now, they weren't at that meeting at the hotel. They weren't part of the documentation that went forward through the night to the next morning to the next afternoon. This got in all the books. And it wasn't until 2012 when I wrote my own book that I corrected all of this with the documents, including the ones I just showed you. And so it's sad that how history can get mangled so easily, right? And then 2 professors from the University of Alberta wrote a piece in the new National Post newspaper in 1991 talking about the Night of the Long Knives and how we were trying to get Quebec out of the deal altogether. That was published in the National Post, which was a new newspaper in 1991. I had 2 deputy ministers back in Newfoundland, and I was out west, and we read it. And then we started to look at all the stuff that had been written over the years. However, it just so happened that these 2 deputy ministers had gotten together 3 days after we went home and wrote up what happened at the conference. It just so happened that I brought a press guy in and did a tape, which I still have, of what happened only 2 or 3 days before. It just so happened that Premier Lougheed put it in the letter to Levesque. The BC people kept their notes, and I was able to call up on all of these notes when I wrote the book to show just how ridiculous that story was, which is still in many quarters the legitimate story of how the Constitution Act 82 and the Charter came about. Absolutely amazing. Now, my book is not in print anymore. It's sold out, the hardcover, but it's you can get it on Kindle, still on Amazon. Someday the sun will shine and have not will be no more, or just put in Brian Peckford and it'll come up. If you want to read all the documents are in that book, in parts of that book, which, by the way, came out in 2012, and we're sitting here today, 2022. Nobody's taken issue with one iota of that. What's in there? The silence has been deafening.
Well, how can they refute any of that, right?
Exactly. But nobody's even come forward to say, well, we made a mistake here, Peckford boy. It was a mistake, Nobody's even come forward to even admit I mean, just crazy. Anyway, the Charter of Rights and Freedoms then has become, in the past 2 or 3 years, and over the years, an important part of the fabric of our country and our Constitution. And courts have gone to it, right? People have gone to it to try to protect their rights and freedoms ever since it was passed, right, in 1982. However, over the years, the courts have taken, and if you got some law school buddies, you'll know this, over the years, starting perhaps even before the Charter was passed, there grew up in the law schools and in jurisprudence generally, the idea of the living tree, and as opposed to those originalists. Here's what the Constitution said. You've got to interpret it as the Constitution was written, otherwise change it. It came along, and Beverly McLaughlin, one of the Chief Justices of the Supreme Court, supporter of this living tree, that the Constitution must change with the times, regardless of what is written. So we have seen, since the Charter became law, a gradual erosion of what is actually the words say and how now it is interpreted. And so the courts are making law, not just interpreting law, from my point of view as an originalist. Okay. But I need to point out there are two schools of learning going on. And the dominant one today in North America, and really in Western Europe as well, is the living tree one. And so that's why you're seeing this erosion of rights and freedoms as was guaranteed under the Charter of Rights and Freedoms, all the way to that Section 1 of the Charter, which all the provinces are heralding. Here's our lifesaver. We have a lifesaver, so we can do all these mandates. No problem. We can do all these because we got Section 1. And I keep arguing back to them, hold on now. Number one, the intent of Section 1 was not to apply to a circumstance like this in the beginning. It was to apply to a situation of war, the threat that the state was in peril, or insurrection, something really serious. Because that's why we put it in the Constitution. It had to be something really serious. Yeah. Right? And sort of to prove that, if you go down from Section 2 just to 4A, you'll find that war, insurrection is used to extend the life of a parliament if there was a war or an insurrection. Well, that's the way we were thinking about Section 1 too. It's only like 2 steps down on the same page, right? There. And it signals what the crafters were thinking about. Matter of fact, somebody said, well, why didn't you even put it into Section 1? We thought it was self-evident. Why would you ever take away somebody's freedoms about a situation where over 99% of people recover and less than 1% pass away, and we don't even know how low that 1% may go, that below 1% that may go? That ain't the peril to the state, and that shouldn't be sufficient to constitute taking people's rights and freedoms away. So my argument is it doesn't even apply. So all the judges, in my view, are wrong to even try to make it apply and accept the government's argument. Number 2, I say, okay, I'm a fair guy. I'm a fair person. Let's, for argument's sake, say it does apply. Then you've got 4 tests to meet. Even under war and insurrection, you've got 4 tests to meet. Demonstrably justify, by reasonable limits, by law, consistent with a free and democratic society. And at least 2 of them they haven't even come close to meeting them. Demonstrably justify or in a free and democratic society. Why? Because there's been no cost-benefit analysis. The courts have accepted just what the governments have said without there being any counter. And remember, it's the governments who have to demonstrably justify, not you or me or those that go to court. They're supposed to demonstrably justify. And that's something I'm going to be pointing out in my essay over the next couple of days. The courts have allowed the provinces and the governments not to demonstrably justify what they did. They just list out, here's how many cases there were, so it was really serious. So we really got to do this. If you read the court documents, right? There's no, and in the court decisions, they've taken away the demonstrably thing and talked about justify. And they are silent about free and democratic society. And I interpret free and democratic society, and I know it to be true. That's why we put it in there. Free and democratic society meant that the Parliament and the people would have to be involved. That's what a free and democratic society is in a parliamentary democracy. So every single province should have had a select committee of the Parliament overseeing this, or in consultation with the government. It shouldn't have been done just by the government. In a free and democratic society, Parliament would be enough. Not open long enough to give the government more power and the public health officer more power. No. Open all through the pandemic, right? As a select committee of the House, or whatever committee, whatever name you want to put on. Okay, that's what should have happened, and it didn't happen. So how can they justify that it meets Section 1 when the free and democratic society part of it is that not even addressed? Yeah, so we have a serious problem in this country. We have a very serious problem in this country, and it's just not limited to the Charter of Rights and Freedoms. It's limited to the role of the state in our society, of our institutions. From the Parliament, there, around the time perhaps you were born, the Parliament of Canada and the MP had some power, and the parliamentary committees had some power. Gradually, it moved to regional ministers, to the cabinet, without a shot being fired, without another law being passed. And we allowed it to happen. And now it's the Prime Minister's office. We have a president just the same as have a president of the United States, without even having to change the Constitution or have it in the Constitution. How many people work for the Prime Minister directly now in the Prime Minister? 1,600 in the Prime Minister's office. And he's got 7,000 deputy ministers and assistant deputy ministers that he appoints besides that. Nothing happens now in the House of Commons unless the Prime Minister says so. Right? Every cabinet minister has got to bow to the Prime Minister. So, and this has happened in the provinces as well. So we have a really difficult job on our hands right now as Canadians to not only restore our individual rights and freedoms through the Charter, but also to restore our institutions generally across the nation. And that second one just as important as the first one. And I don't know how we're going to do it, given where we've gone, and given the introduction of that Emergency Act, which, by the way, got taken away very quickly because investors said, we're not going to invest in a banana republic. Get rid of that now. It wasn't the Senate, even though the Senate played a greater role than it normally plays in sort of making it a question and arguing. Some, senators actually stood up and were counted. But at the end of the day, we are in a very, very difficult position through the Charter of Rights and Freedoms. Now, the only salvation I have, and this is what my ending story is this, is that to this very moment, all the high courts have not ruled. Every province has a court of appeal. So the one in your province, for example, that was at the Supreme Court level or Superior Court level. There is a court above that called the Court of Appeal. And that's the top court in every province. And the Chief Justice or the judges on the Court of Appeal have not heard the Charter decision yet, or have not rendered their decision on it. So our only hope on the Charter and it being restored is if these courts of appeal suddenly get wise to what's going on and are independent enough to rule that the Charter was broken and make it quite clear. How many people are we talking about? It's highly likely that between 20 and 30 people in Canada, unelected, called judges, will decide whether that Charter is any good or not. Because what will happen is all of the provinces, the courts of appeal won't hear it. I don't even know if there's cases in every single province. There's likely to be 3 to 4 provinces. I'd say 3 provinces, might be 4, and it could even be 5. So let's go to 5. How many judges will hear it in each province? 1 to 3. Let's say 3s are 15. Supreme Court of Canada, then it will go to Supreme Court. How many judges there? Total? 9. 9 and 15, 24. So that's where we are. And I got involved because early on, not on the Constitution side first, I got involved early on before the mandates even came in. When I started to read like everybody else, we thought everybody else was reading, about the studies that were done early on, which showed, just one second now, hold on. And then we had a doctor in British Columbia, Dr. Hoff, who he was in Lytton, BC, and he was a doctor there for 25 years, originally from South Africa, one of the most gentlest, nicest people you'd ever want to meet, because he's spoken with me on stages now all across Western Canada, especially in British Columbia. And suddenly he had 9 patients turn up in his office with injuries, and they had been vaccinated. The First Nations were vaccinated first. And he had 9 with very weird injuries that he couldn't diagnose. He had already made a number of comments locally that were still experimental and hadn't gone through all its tests. And he was worried about it being also gene therapy. So he expressed some views. So he went to refer his patients to a hospital in Kamloops, British Columbia, the closest hospital, where he had visiting privileges as well. And they refused to see them to this day.
Wow.
So when I heard that, I called him. I have a blog, and I blog a lot, and every day I get between 8 and 20,000 a day from all over the world in on my blog. So I want to do a blog on this and bring it to the attention of at least people who go into my blog. And so I called him, and sure enough, he confirmed all this to me and said they were really, and a lot of them now are permanently disabled, permanently sick. And anyway, none of the surgeons, specialists, because he said, I'm an MD, specialists might know more than me. So we refer, as we do in everyday life across Canada, MD refers to somebody who knows a bit more, called a specialist. So they wouldn't see him. So I thought this was very strange. And then they started to accuse him of having, what was it they called it? Vaccine hesitancy or something. And this was some kind of a crime. I can't find it in the criminal code, but it was some kind of a crime. And because he showed some hesitancy in participating with everybody else. And then he took his hospital privileges away. Wow. Of course, the greater tragedy of all of that nature didn't help him either. The whole town burnt down in a forest fire, including his office.
Oh my gosh.
And he's living now in a cabin up near Kamloops on a lake that he had. And he's been harassed. And the College of Fisheries, College of Physicians and Surgeons are trying to delist him.
Wow.
As we speak. So when I got involved, right, and I saw that happening, and then other independent research came out. I said, this is not all. This is not. The other thing that really bugged me, when somebody doesn't stand behind their product, we're used to going and getting a car and having a warranty, right? You can go into the store and almost everything got some kind of a warranty on it. Some of them are not all that good, but it's got some kind of a warranty there. And here is this great big company called Pfizer and Moderna saying that, oh no, we're not liable for anything that might happen to our product. We're scot-free. I mean, I don't know where you're going to go to get redress, but no. So when I found that out, that they were completely immune from any liability for anything that happened to their product, that was enough for me. That was enough for me. So then, of course, in came the governments with things, and then I had to get back involved in the charter and start arguing this, and then only to find out, to my greatest surprise, I was the only one arguing to try to defend the charter against this onslaught of provincial and federal and territorial mandates, because all the 3 territories have parliaments too now. So there's 14 parliaments in Canada, not 10 or 11. And they've all, followed the federal lead and the lead of the White House and the lead of the boys over in London when they took their orders from that group over there that were funded by Bill Gates, by the way. Forget how many million, I think it was 36 million that group over there, that Oxford group or whatever it was, got. And there was going to be millions dying on the streets and all of that. And then when that sort of couldn't be justified. They took a group out of the University of Washington in Washington State in Seattle, and they used their dogma and data for quite a few months until that was no longer used. And then they had enough then. There was enough fear in everybody that the deed was done. And to this day, now walking around this morning, even here in parks along Vancouver Island, the masks have been lifted now. Over 50% of the population is still going around with masks on.
Yeah, ours lifts tomorrow, and I'm certain most of the people are going to still be going in wearing masks despite the lifting of those measures.
Anyway, I said enough, so I'll stop and you guys ask some questions.
So just to back,
I want to give you all that background, So.
Yeah. That was perfect. Thank you so much.
So just to be clear for our audience, you were one of 9 other premiers and Pierre Elliott Trudeau at the time who negotiated the Canadian Charter of Rights and Freedoms. So right now, you're saying the federal government is infringing on those rights. Could you tell us about the lawsuit and sort of what about that?
And the background to that is people started to ask me, because I was on a number of Zoom things, right? None of the mainstream media, by the way, have totally ignored me through all this. Will not carry a letter even.
Yeah.
Won't carry anything, zero. I am persona non grata.
And they used to, right? They used to, you mentioned at one point in time, you publish your letters, and then they've...
I always publish, National Post, I always publish my letters. They call me and say, we got your letter, Mr. Peckford, amongst a whole bunch more. And, this is interesting. So, can we cut it down a little bit? And I'd say, okay, I'll go to work on it and I'll send them another draft. And they say, oh, that's it. That's in good. That's under 800 words or whatever it was. And they carried Times columnists in Victoria carried my stuff for years. So, and CBC and CTV and Global would call me every now and then about some national issue that they remembered, or somebody told them that I was involved in when I was a premier and I might have a different take or another take on it, blah, blah, blah. All that got stopped, right? Just right out the door. Anyway, when I started doing these public meetings where people were attending and listening to the history of the Constitution up to including the Charter, it went on for several months. I mean, every one of them were packed to the doors and people standing outside. Like, couldn't get everybody in the hall. Still to this day, people are yearning to know what rights they have, what power, what freedoms they have, and are they now being taken away, or what's happening? In any case, I got home one night, and my wife and I said that night or the next morning, I said, somebody one of these days is going to say to me, Brian, you're a good orator. You can explain yourself pretty well. You're a good guy. You're talking the talk. How about walking the walk? So I figure I should perhaps start walking the walk. How could I do that? Quite simply. And of course, the federal government had come out with its mandates. Now I wasn't able to travel. And that's what's prevented me from speaking in provinces like yours, right? I mean, I'd love to come out to Manitoba, and not just in Winnipeg, but in different parts of Manitoba, and do the same thing I'm doing on Vancouver Island. Right? I've done 12 or 15 of these now. And I'm a rural person by nature. I was born in rural Newfoundland. And so I have a special affinity for swamp and for rural people, for basic, fundamental people. Right there. And they know it when I go and speak to them. They know it right away. They can pick it up right away. People I'd never met before. And so I said, yeah, I'm going to take a look at this. So the federal mandate on travel attracted me right away, even though a bunch of provincial mandates did too. It attracted me for a number of reasons. One, on this travel thing, that is federal jurisdiction, so they right across the country. That applied right across the country. Everybody could relate to that right away. They had a brother or sister, mother, aunt or a business in another province, whatever. They traveled to other provinces. We're a traveling nation. I mean, let's not forget, part of the reason why we're a nation is because of the railway. What more travel can you get than that? And the Mackenzie River, and a host of other rivers, including the St. Lawrence Seaway and all that. We're a nation of travel. And the early explorers all go travel. right? So we're the second largest country geographically on the globe. So, travel has been very much part of our history. So I thought everybody could relate to that quite easily. And number two was I would be going to the Federal Court of Canada, then to the Supreme Court of Canada. I only had 2 steps where all the other mandates that start in the provinces are 3 steps, much longer. And so this travel thing attracted me. And then I contacted the Justice Centre for Constitutional Freedoms in Alberta, but which is national, had read a lot of my stuff, and both on my blog and other Zoom calls, stuff like that. And so we almost they almost came halfway, and I came halfway when we met. Oh, yeah. Are you interested in doing a challenge against the federal government? I'm saying, are you interested in helping me do a challenge against the federal government? So they've taken on the cause of representing me in court on this challenge with an outside lawyer as well. So they hired an extra lawyer. And so I sat down with them over Zoom and whatever. And we've now got everything filed. And the case is sort of up and running in the sense that both sides are now exchanging documentation, both on the medical side and on the legal side and all that. And I'm likely to get a hearing in August or September with all the former work, preliminary work done. Yeah.
Where do you see this going, this lawsuit? Do you think this will rule in my favor?
This will go to the highest court. This will go to the Supreme Court of Canada, because if I lose, I'm going to the next court. And I know if the federal government loses, they're going to want to go to the Supreme Court of Canada. So this will end up in the Supreme Court of Canada at some point next year. And we'll see where it goes from there, right? But if we are successful, then it will put in jeopardy a lot of the mandates that the provinces had in. There's absolutely no question. Remember, it's Section 6. Remember the 4 main sections of the Charter of Rights and Freedoms for your freedoms and my freedoms. Section 2, right? Speech, worship, conscience, religion, press, and freedom of assembly and freedom of association. That's all in Section 2. Isn't that beautiful? I mean, when I read them out, and I've read them now or recited them hundreds, if not thousands of times in the last year and a half, and guess what? I get just as much pleasure out of reading them today as I did the first time I read them, if not more. I just beautiful, right? So that's Section 2. Then the Section 6, right? Section 6 is the right to travel anywhere in Canada or leave Canada.
That's being infringed upon right now.
No conditions. No. Not just in one province, not just in some province, not just when it's convenient, right? This is open-ended. This is a right in the Constitution, not in the Federal Act, not in the Provincial Act, but in the Constitution of our nation, right? And I don't think this is what the judges understand anymore. I think they're confusing very often the Constitution with federal acts and provincial acts, right? I don't think they understand the enormity of what it is they're talking about here, right? We did at the time. Then Section 7 is a glorious one too, because it's just a small sentence, part of it. The right to what? Life, liberty, security of the person. Wow. Security of the person. In other words, nobody can touch me unless I agree. Nobody can jab me unless I agree.
No one can put a vaccine into me unless I consent to that.
Absolutely. That's the security of the person. Oh God. And life, liberty goes along with that too.
And
How can you have life and liberty? How can you have life and liberty if you haven't got control over your own self? I mean, like, it's insane, isn't it? Yeah. And then Section 15, and I'm finished on that side. Every Canadian has a right to equality before the law. I say in my speeches, my public speeches, every snowflake is unique. Every human being is unique. Equality before the law for all people, right? From Tofino to Bonavista, from Iqaluit to Niagara. We're all equal, right, before the law.
Yeah, we're not dividing the vaccinated and unvaccinated and treat them differently. That's beautiful, honestly. Go ahead.
Nothing. Go ahead.
What happens if the court system fails to uphold the charter?
If this goes and we fail on upholding the charter, right now this democracy is not only under attack. We don't have full democracy until we get restored, but it will be permanently lost. We will not be a democratic country. There is an organization around the world called Freedom Watch, and they look at countries all over the earth year, and they give them a label: free, partly free, not free. We will go from free to partly free if we lose this.
So as you mentioned earlier, in order for the federal government to impede upon the Charter of Rights and Freedoms, the government must demonstrably justify this in both a free and democratic society. Sort of what the government has been saying and the media has been saying is that this is for the greater good. This is for the community. So do the rights of the collective, of the greater good, supersede the individual?
No, not in my view. And demonstrably justify, in my view, and this is common throughout all of Canada for decades, and you've heard of it many times, a cost-benefit analysis. When I was Premier, lots of times when we were introducing new things, the first thing you do is have your bureaucrats, people who work for you, go and take a look at this. Is this got more benefit than cost? Right? And does this have any more benefit than cost? So you would think that would be the automatic thing that a government would do if it was going to suddenly curtail your rights and freedoms, because it's right there in that section 1, demonstrably justified, please. And they have not done one cost-benefit analysis. And I stand by that. And if I could get before a judge and just explain that to them, where is it that the province has, in any of these cases that have come to date, they've proven, they've demonstrably justified this to you. How can they just demonstrably justify it by giving you all the cases, 95% of which were false anyway, right? Nobody went to hospital. Only less than 5% of the cases ever went to hospital, right? And so how can you, without giving the other side of how many surgeries were delayed by the lockdowns, how many people died because they didn't get their surgery, right? How many other appointments were lost? How much from suicide and depression have we lost? And on it goes. And by the way, it drives me crazy. Douglas Allen, a professor at Simon Fraser University, I don't know the man from Adam, but he, in April 2021, months before these courts in Manitoba and British Columbia came out with their decisions, published a study. That's how early it was. And it was even earlier than that in other countries, where he showed, looking at 80 studies from around the world up to then, that the harm, the cure was worse than the disease. 80 studies from around the world. Nobody ever quotes it. He couldn't even get in the papers with his study. And 3 or 4 months later, he was contacted by Epic Times. And they did a story. And what was the story? He couldn't get his study published, or couldn't get his study carried by any of the mainstream media. And nobody to this day is not mentioned in any of the documentation, in any of the court decisions. Here's a homegrown professor, right? A Canadian professor who's been completely vindicated since that by, hundreds of studies. Hundreds and hundreds of studies. But he even says in that study that 90 days after the pandemic started, there were people coming out with credible data as to how this thing was going to not be beneficial.
Yeah.
And so just give them a little leeway. 6 months in, the governments ought to have known, because it was available, ought to have known that the path they were on was a disastrous path. Not even counting the 50,000 dead from the vaccine, 25,000 in the United States and over 30,000 in Europe as we speak, and 1.5 million injured.
They won't even speak about that. or allow that to be written in anything because it promotes vaccine hesitancy. But these are facts that the population has the right to know about.
Exactly.
Do we not have a pandemic prepared plan for a situation like this?
Yes, David Redmond. Have you ever spoken to David Redmond?
No, we have not.
He's linked into our email chain with them. I'm familiar with who he is.
You got to talk to David Redmond, or go in and check out his name, because this guy was in the armed forces, retired, became emergency measures organization head in Alberta, revamped their legislation. I remember when this came in, I was premier when all these emergency measures organizations came in. Every province has one, and what are they there to do? They're there to respond in case of any kind of emergency or unusual circumstance, including the one that we had, and the whole thing was shelved. The only people that were listened to were a bunch of clinical, health professionals who saw it as a great opportunity to enlarge their power. Yeah. That's what it boiled down to.
And we only really considered their opinions, you need to take into the opinion people from different spheres, right? Not just that one sphere.
And that's what the emergency measures does. It went to all the departments and they developed plans, multifaceted plans, not not single issue plans, right? So the plan was all encompassing and looked at the whole society and how it was to be impacted. This was not done. And this is a tragedy, and all the government should be held accountable for ignoring those emergency measures organizations.
Absolutely. So obviously, as Students Against Mandates, we have a focus on the universities. Section 2 of the Charter states that everyone has the freedom of conscience and religion, and the universities have been denying applications for religious exemptions. Is it possible to challenge universities on the vaccine mandates on this basis? And are they infringing on the Charter by denying these exemptions?
Yes, in my view. I have a student who just wrote me from University of Guelph, where Dr. Bridle is, and she's about to lose her job as she's on staff there because she's not vaccinated. And I'm going to write her a letter and send it to her, and she's going to include it with her appeal to the president and to vice president of personnel or whoever at the university, in which I'm going to say, by denying her job, you are violating the Charter and quote those actions, including the right to work, by the way.
Yeah.
In her case, because she's working for the university. But even students have a right to an education, a right to go to a university, right? But life, liberty, right? The whole bit. Yeah, freedom to associate even, for that matter. No question. No, and they're getting away with it. You see, they're under the cover of the government. The government says lawyers tell them you can go ahead and do this. We'll use Section 1 and make that work. And so the big fight now, and that's why I'm going to put out this essay, because I want to zero down on how the courts, in very simple language, I won't get into all of where they talk about, under administrative law, you can do this. Under division of power law, you can do this. Right? This is gobbledygook. Right? We all know what that's all about. And so they escape through these wonderful mechanisms that they created themselves.
Yeah.
But down to basics is what I'm going to be talking about. I'm saying that you have not, right? Number one, Section 1 doesn't even apply. And number two, even if it did apply, none of the governments have met the tests.
Yeah.
And then I'm going to quote them where they've taken demonstrably justify and used justify, where they've eliminated the supremacy of God and the rule of law altogether. I think it's in the Manitoba case where it's not even mentioned. And I drive people crazy when I talk about this because we've become so secular as a nation. So here it is. When I say to people, "What is the first words of the Charter?" Section 1. Section 1, Brian. Section 1. I say, no, it's not. There's something before Section 1. It says, whereas this country is founded on the principles of the supremacy of God and the rule of law, colon, not a period. Whereas in the court decision in British Columbia that I read this morning, the judge actually quotes that in number 2. He says, this is a charter case, and the Charter of Rights and Freedoms was passed in 1987, and its preamble says, okay? He actually puts it in there, number 2. Then he goes on to change it and make it a sentence with a period rather than a sentence with a colon, and takes out whereas. So that now it's just a statement, and it's passive, right? If you know anything about English grammar, it's passive. It becomes a passive thing, right? Nothing more to be done with it. Whereas, when you have whereas in it with a colon, it's an active thing saying whatever comes after this must take full account of these 2 principles.
Yeah.
First, since day one, these principles have been ignored by the courts. So we're fighting a heroic battle here to actually bring the charter back to where it was on the day, the November the 5th, 1981, when it was signed. Then it was pure.
Yeah.
Since then, everybody's been trying to contaminate it. But the words are there, and until they're changed, and I say to Christians, by the way, most of the buildings that I've spoken in on Vancouver Island have been Christian churches. And especially evangelical Christian churches. It's quite interesting. It's quite interesting. And you know what I found out? And I was raised a United Church of Canada person. Okay, my dad wasn't in the clergy, but he was in the church. He was in the choir. He sang. He played the organ. And he loved his church, and he loved the United Church of Canada at the time, which has become more or less like a social agency these days. But in any case, in those days, it did talk a little bit about religion. But I found out, and because in Newfoundland we had religious schools right up until I left office. And I found out, and through like my wife who was raised Anglican and others, I know a fair amount about mainstream Christian denominations. Very few of them teach. This is the trigger for these evangelicals. Teach early Christianity. The Christians of 200 AD and 300 AD, they were persecuted. And Carol and I went to Turkey years ago, and we went to Cappadocia in the middle of Turkey. And it was in Cappadocia where they went underground, physically. The nature of the rock allowed them to go down and build different levels of communities under the ground and hide away from those who were persecuting them. Guess what? All these evangelical churches teach that every week in their Bible studies. They know. And when I said up in Black Creek near Campbell River, north of here, at a big meeting, halfway through my speech, I said, and I was in Cappadocia, Carol and I were in Cappadocia, and we saw the whole congregation. Couldn't believe it. It was almost like a gasp. He understands. And my point back to them was, no, you understand rights and freedoms because you learned about it from the early Christians' history. And mainstream Christianity doesn't teach that anymore.
Yeah. So
mainstream Christianity has been more or less on the side of the governments, and the evangelical Christians have been on the side of the charter. An amazing turn of events.
Well, it just shows having that background, that education can help them even see parallels, right? And that kind of leads me to my next question. What should young Canadians know about the Constitution and the Charter of Rights and Freedoms? Why should they be educating themselves right now, and why should they care about it? That may seem like an obvious question, but...
Yeah. Well, what's happening out here on Vancouver Island in particular, the group down in Victoria, which is a fair number of students and young people, and they formed an organization called We Unify Canada. And they are appearing before the legislature every week on Saturdays and Sundays, and a big one once a month. Mm-hmm. Okay, and they're having a big impact. And the last one they had 13,000 turned up, wow. And the whole metropolitan area of Victoria is only about 300,000. Wow. You know. Winnipeg is about 600,000 or 700,000 or close to 1 million. So this is a small city in Canada, but they're getting 10 and 13,000 out. Truckers as well. They truck all the way from the north part of Vancouver Island down to Victoria for the day. I spoke there. We'll be speaking there again in a couple of weeks. Yeah. So that's one thing. students can do is get themselves involved in these organizations that are, are on side with your point of view. I always say to people that snail mail is better than the email. I'm so sorry. I pushed the wrong button. I just deleted your letter. Oh my, I'm so sorry. So this is what happens when you send it by, there's a cyber attack tomorrow. Right?
Yeah.
But if you do a physical paper, keep a copy of it and put it in that old mailbox, it's got to go to a mailbox at that minister or premier's office. It's got to be collected out of that mailbox.
Of it, yeah.
Under law, it's got to be collected. It's got to be brought to the minister's office, and it's got to be collated. And then, quite likely, the press secretary or somebody in the minister's office or the premier's office gives them a tally every week of how many are writing in and what they're writing in about and how many are in favor and against stuff. So you have a better chance of having an impact, to me, from a snail mail. Now, I do the email automatically anyway, just to have it done, right? But I would write a letter, a physical letter, and try to meet with your local MLAs and your MPs. That's what's happening out here. I had encouraged a lot of people, and I'm getting I don't know how long I've been on here, but however long I've been on here now, I will go into my inbox and perhaps I'll have 250. So you can see how many I get in a day.
Yeah, it's a lot, and you'll miss some of them, right? I mean, I even do, and I don't get nearly that many.
Exactly. But there's people calling me and writing me, asking me for either help or what should we do. Ask the same question you just asked, right? Yeah. And I try to get back to everybody, and everybody knows I try to get back to everybody. So that's why they keep writing me.
It's a vicious cycle. You're gonna get more and more emails.
I am.
Yeah,
it's crazy.
That's good. So recently you were on the
and have you got a group formed on campus, which is great. I'm glad to see that.
Yeah, we have a huge community all across Manitoba, students, parents, concerned citizens, and even people all across the world. So it's been great. The community is fantastic. Now, out of respect for your time, we're gonna close up here. I'm gonna pass this along to Brandon to ask the last question.
If you had a message for university students or young people in general, for that matter, what would you say to them, and why should they be paying attention to the Canadian Charter of Rights and Freedoms right now?
I would say, if you're not doing history now or doing anything on that, please get a few books or go to learn about your Constitution, right? And from the freedoms and rights point of view, 1867, no charter, nothing written, all common law. 1960, yes, we started to get something written, right? But it was only federal, and then it goes to 1982. You can do a quick review like that. If somebody wants to go in and download my book, they can, but I'm looking for another book here now. This is my office, and this is where I have most of my books. And there's a book out. It's a book that deals with how our institutions have deteriorated. So as a student, as you learn about how the Charter came into being, it might be a bad idea for you to also. Here it is. It's only out 2 years. It's the best book about Canada's governance. It's called Democracy in Canada, The Disintegration of Our Institutions, and it's written by who's now a professor at the University of Moncton, Donald J. Savoy. Don't let anybody tell you anything is better. If you want to know currently and how it happened, how our parliament deteriorated, all right?
This is the
and
book.
Our government deteriorated. This is the book. This is his sort of epic. He's written other books over the years. He's been at this for decades. And he's a real scholar on governance. Okay? This is the book for you to read, to just show just how far we've come, and it parallels, what's happened on the constitutional side. So it's a really good parallel for anybody really interested in Canadian history, past, present, and where are we going. Okay, well, this is the one.
Yeah, that really will be, I think, what saves us as a country is education, just educating yourself on the history and everything. So
if I had a word to say, I would say, get educated quick, get informed, better said, quick. I don't like the word educate. get informed quick, and then get involved right away.
Absolutely.
Physically get involved in something to help pursue this, right? To help advance this cause. That's what I would say. I taught school for 4 or 5 years, and I enjoyed every minute of it, by the way. I enjoyed every minute that I taught. By the way, even then, I introduced civics into the curriculum. It was gone in 1987. And then history and geography went soon after that and fused into something called social studies, which, what is it? Is a blob, right?
Yeah, exactly.
I learned history when I went to school, and I learned a lot of history at university, right? And so our whole right. So civics needs to get back as a mandatory subject in our classroom from at least grade 7, grade 8 onward. It needs to be mandatory. And what I taught that year, I only taught 1 year because I wasn't there very long. And by the way, I introduced Shakespeare in the grade 7. So everybody who came through my program for that 4 or 5 years came out of grade 12 with 7, 8, 9, 10, 11, 12, 6 Shakespeares. Most of them went into English 2, didn't have to do English 1 at university. As soon as they told somebody that they had 7 Shakespeares already, they said, oh my God, you better go on in English 2, right? But that was possible. I did that in grade 7 and introduced civics in the grade 8. So I've been at this a long while. I've been at this all my life.
Yeah.
Yeah.
Since I was a student, I've been at this.
Yeah. And that's why I'm really fortunate that we have this conversation with you.
Yeah. So it's important, right? And by the way, I wasn't born a Canadian. When Newfoundland joined the Federation in 1949, I was 7 years old.
And now you're fighting for all Canadians.
Now I'm fighting for all Canadians. And at the Constitutional Conference, where I said we had a bargain, it was all a bargain, I had to give up any more say over the fishery to get that deal. I was holding out to get some say over fishery, which had been given away when we joined the Federation by Newfoundlanders. We gave away all of our jurisdiction over fishery. We should have had a shared responsibility with the federal government over fisheries, because that was our main industry for 400 years. But I relinquished it for the sake of what? Canada and the Charter.
Amazing.
And you're fighting for it today.
And I'm fighting for it today.
Well, I think that's the perfect place to close this. Thank you so much, Mr. Peckford, for joining us. We really appreciate your time.
Thank you. And good luck with the battle.
Yeah, good luck.
And I'm so glad you reached out.
Oh,
because that's what you have to do.
I'm so glad you responded to your email.
Yeah, because if you don't try, you never know.
Exactly. Thank you so much. Have a great day.
Nice
and
meeting
you too.
Thank
Bye.
you.
Bye.